A lot of people ask me questions about underage drinking in Pennsylvania. The most common dilemma is whether they should plead the case down to a disorderly conduct or whether it makes more sense to keep it at underage drinking. And the reason for this is that an underage drinking conviction carries a driver's license suspension. For some people, that's the primary consideration. For others, they're more concerned about the record. Somebody who's under 21 might be looking at going to college and then possibly graduating and getting their first job or going to graduate school around the time that they turn 21. Disorderly conduct is not expungible for 5 years, whereas underage drinking can be expunged from a record as soon as you turn 21. So in those situations, if somebody's 20 years old and gets a citation for underage drinking, they might only have a few months until it can be expunged if they're convicted of underage drinking, or another 5 years of having a disorderly conduct on their record. So this is an important consideration that should be discussed with a lawyer, and if it's important to you, you want to make sure that you make the right decision. Underage drinking has a lot of good defenses that can be raised. There's a case called Commonwealth versus Brigidi, which allows someone generally to suppress in almost any jurisdiction in Pennsylvania the results of a little handheld breath test device that the police may have administered. So it might be worth fighting the case, and the worst thing that happens if you're convicted of underage drinking is then you get an expungement in a few months, whereas if you go to disorderly conduct, in that situation you can't get it expunged for 5 years.